Good afternoon. I think we can get started. I would like first to introduce our panelists. So we have today a distinguished guest, Luigi Nascimbene, who's currently director at the PwC Legal in Milan, and formerly a well-known practitioner in Milan, working for many years, I think 15 years, for law firms, including our law firm, the Milan office of CLEARY GOTTLIEB. Then we have Cesare Rizza, a senior colleague in our Rome office. Cesare has extensive experience in Italian and EU competition law, and also in EU law at large, because Cesare has been working for many years in Luxembourg as a law clerk, référendaire, for Professor Antonio La Pergola, who was Advocate General at the Court of Justice and then judge at the ECJ in Luxembourg. And finally, Natalia Latronico, a colleague member of our Italian antitrust practice group, currently seconded to the Brussels office. Thank you for being with us. Today's topic is competition law in labor markets. This topic has emerged in recent years as one of the new areas of intervention, public enforcement, with many competition authorities declaring that this area of intervention is among their priorities, and publishing guidelines, releasing public speeches, including, for example, the 2024 policy brief by the European Commission, in which these competition authorities have declared their intended purpose in this area. And this policy momentum is coupled with an acceleration in public enforcement. Many competition authorities have already adopted their decisions condemning a variety of conducts, ranging from wage fixing, no-poach agreements, no solicitation agreements, collective agreements among employees, and also agreements regarding the exchange of confidential information concerning the economic terms of the employment agreements. So I leave now the floor to our panelists, starting with Cesare, who will provide us a brief survey of the recent developments in Europe with a focus on the recent European Commission decision in the food delivery market. So, Cesare, the floor is yours.
Thank you very much, Matteo, for this introduction. Thank you all for being here today. If we can, thank you. So, the tide has finally turned in the European Union in this area of antitrust enforcement. Finally, on June the 2nd, the European Commission has adopted its first decision ever in the enforcement of antitrust in labor markets, the online food delivery services decision. This is, in a way, the fruit of seeds that were planted a long time ago, because already in 2007, in an official document, we have a reference to no-poach agreements being market-sharing agreements for the purposes of Article 101. This was a reply of the Commission to a parliamentary question. But then somehow 18 years went by without the Commission taking ever action, although, as we know, enforcement in this area has been quite hectic in other jurisdictions, especially the United States, but also in the European Union, as we will see in a while. In online food delivery services, the investigation was formally initiated in July 2024. A couple of months before, the DG Comp had issued a policy briefing, which it laid out its policy in this area, and it stated that wage fixing and no-poach agreements in most cases qualify as restrictions by object, equivalent to purchase price fixing and supply source sharing. It also stated that these kind of agreements are unlikely to be eligible for exemption under Article 101, paragraph 3, whereas under strict conditions, they may be characterized as ancillary restrictions and therefore fall outside the scope of Article 101.1 altogether, As you know, under the ancillarity doctrine, when you have a legitimate transaction that is pro-competitive or competitively neutral, and then you have a restriction of the freedom of contract of the parties to that transaction, which is secondary. This restriction may be characterized as ancillary to the extent that it's directly related to the operation of the main transaction, and it's also objectively necessary and strictly proportionate to it. In the competition, in DG Competition's policy brief with regard to wage fixing and no hiring agreements, the DG Comp referred to clauses, restrictive clauses in the context of R&D cooperation, as well as in the context of vertical distribution, of course, provided that the clause is duly proportionate, for instance, in time and space, or limited to certain key employees, senior executives, for example. Finally, the brief also states that most cases of these restrictions will be dealt with by national competition authorities because of their geographic scope. And in the second slide, we can see a list of all the decisions that European national competition authorities have taken in this area. You will notice that there is another commission case which is actually pending, the data center construction sector, where dawn raids were carried out last November. And there is, of course, a reference also to the recent decision of the Autorité de la Concurrence in the engineering, technology, consulting, and IT services sector, with fines that were much lower than in the commission case. I must say that comparing the two decisions, I find the French decision to be much more interesting for two reasons. One is that the decision of the Commission was adopted in a settlement regime. That is, the parties accepted that 10% fine reduction in exchange for admitting their liability for the conduct. So the Commission really didn't have to set out in full its statement of reasons. Its statement of reasons is quite succinct, and at times it sounds like a mere repetition of what is said in the competition policy brief. The other reason is that in the French case, the no poach restrictions were naked restrictions, whereas in the Commission's case, the no hiring agreements were part of a single and continuous infringement, which was characterized as a by-object infringement. So it was a bit the same case as they had in 1999 in the pre-insulated pipes cartel, where there were other conduct restrictive competitions, such as geographic market allocation, exchange of sensitive information. In that case, what is interesting, there was a collusive poaching agreement, which is the opposite of a no hiring agreement. That is, the members of the cartel agreed to hire, to try to lure away work from a competitor, from a third-party competitor that was not part of the cartel, in order to boycott it, weaken its position as a competitive force, and also as a way of extracting sensitive information. Other than that, I think the reasoning, the statement of reasons in the French decision is very interesting, is very elaborate. Moving to the Commission case, it all started with a minority agreement, the acquisition, for the minority interest by Delivery Hero in Glovo, and in 3 different rounds, Delivery Hero increased its participation in Glovo, and then in July 2022, it acquired sole control over the company. At each round of negotiations, there were restrictive clauses, no hiring clauses, and no solicitation clauses agreed among the parties. One interesting aspect discussed in the decision is whether, because these clauses might have been considered to be in support of the minority investment to the duty of loyalty among shareholders of a company, they might have been characterized as ancillary. But in the end, the Commission decided this was not the case because it held that these clauses were not limited in space or in time. They were reciprocal, and also they applied to some shareholders, to some investors rather than others. So it was not clear at all that they were objectively necessary and proportionate to the objective of protecting the investment in itself rather than the investors. Last thing, this decision was adopted based on information that the Commission received from an unnamed national competition authority, plus from an anonymous whistleblower, whereas, as I probably mentioned already, the French case started on the basis of leniency applications. I think this is all I wanted to say about this decision. I would close with maybe a couple of interesting aspects that I think this the last one. Thank you. Okay, this one. That these cases raise. The first aspect is the position that the Commission is taking in the policy brief, in the decision, and also at the hearing before the Court of Justice in the Tondela case, in the pending Tondela case. The Commission is saying, since we are dealing with by-object restrictions which are neither atypical nor complex, because they fall squarely within the provision of Article 1011, letter A, letter C, then our examination of the economic and legal context of the clause can be limited to what is strictly necessary to establish the restriction. As you know, according to the established case law, when you have a category of coordination that normally reveals a sufficient degree of harm to the proper functioning of normal competition, before you decide this is a restriction by object, you still have to assess the content of the restriction, its context, and its objectives. According to the Commission, this may be done rather quickly in the case of restrictions that fall within Article 1011. Well, Advocate General Emilio, in the Tondela case, strongly disagreed with this reading, which the Commission actually based on the wording of the Toshiba judgment of the Court of Justice and also the severe judgment of the General Court. They really say what the Commission said, but he strongly disagreed, and it seems there might be a change of assessment of this principle. We will see, of course, when the judgment is out. He thinks there is really no reason that in all circumstances this examination should be done in a superficial and cursory way. Context must be assessed in depth. And this is the reason why, in his opinion, he's suggesting the referring court, which is a Portuguese court, to treat the particular no hiring restriction, which is the object of the case, as a by effect restriction rather than a by object. You will remember this was a no hiring agreement, a temporary no hiring agreement between all the first and second division clubs of the football Portuguese league during COVID-19. What happened is that the league was extended, the end of the league was extended, but in many cases, the employee contracts of the players expired before then. So basically what could have happened is that the most wealthy clubs before the end of the seasons could have hired these players that were basically on the market, and this could have altered the integrity and the fairness of the sport competition and its results. So that's why all the clubs and the National Association thought it would be a good idea to have a no hiring agreement until the end of the season. The Portuguese Competition Authority thought this was a no hiring agreement and fined 31 clubs and the National Association. Then the Portuguese court is now referring the matter to the Court of Justice, and the Court of Justice will decide whether what the court was decided, the Portuguese court decided was correct or not. Advocate General Emilio is suggesting to treat this kind of agreement as a by effect restriction. And then last point, should we really care about the harm that employers inflict to workers through wage fixing and no hiring agreements under the lens of antitrust? Is this the appropriate instrument to deal with this harm when we have other tools such as wage regulation, job protection, union support. Plus, according to the Court of Justice, lately, even in the Servizio Elettrico Nazionale, point 46, the main objective of competition is the protection of consumers, maximizing the well-being of consumers. So why should we care about workers? Workers are not necessarily consumers. Consumers may even benefit from these restrictions on workers. I find interesting what what DG says on this specific point in its competition policy briefing. It is clear, and it also appears from the decision, from the press releases that accompanied the issuance of the decision. The emphasis is on extraction of wealth from workers by the employers. So this is clearly the main concern. The competition policy brief says wage fixing firms, in the case of wage fixing, maximize joint profits by setting wages equal to the monopsony wage level via a reduction of labor demand, with the side effect of reducing output and increasing downstream prices to the detriment of consumers. So harm to consumers is considered literally as a side effect. What does it mean? It's not clear, but either DG is saying that the fact that consumers are in a different market than the market in which competition is restricted, because of course consumers are in the downstream market and competition is restricted in the upstream market, this should not matter. Consumers should be protected anyway, although their harm is a side effect. Or maybe the Commission is saying that the existence or not of negative effect on consumers should not really matter when the reason of antitrust intervention is the protection of worker welfare, so a different category, a different notion of welfare. And this has long been recognized in US enforcement of antitrust. So maybe the conceptual framework will also change in the European Union. It will also be interesting to see what the Court of Justice will decide on this point in its Condela judgment when it will be out. I stop here and I thank you for your attention.
Thank you. So, as Cesare mentioned, the enforcement of competition law in labor markets is still at an early stage. However, I think there are a number of questions that are already worth discussing, as they may have a significant impact on enforcement, on companies' compliance strategies, and ultimately also on legal certainty. So 3 issues I would like to briefly discuss today. First one is acqui-hires, and how should competition authorities intervene to tackle them? Are the current instruments adequate for this goal? Second one is the calculation of fine, and this will go back to what Cesare mentioned about what is the ultimate goal of protection here for antitrust labor-related infringements. And the third one is the risks of benchmarking in the HR sector and what is the impact on companies' compliance strategies. So first one, acqui-hires. These are usually defined as cases where the acquisition concerns all or part of the personnel of a company instead of acquiring the company as such. Sometimes this is coupled with the acquisition of tangible or intangible assets such as IP rights. And this is a phenomenon which has recently been on the rise, especially in the tech sector, with the rise of artificial intelligence startups and the ensuing competition for top talent in this sector. So this raises a number of interesting questions from an antitrust viewpoint. And the first one is, should we conceive these acqui-hires as the new or potential form of killer acquisition? And if so, are the current tools that competition authorities can use, both at EU and national level, good enough to allow them to review them if this is needed? And I think some answers to these questions can come from the Microsoft Inflection case, which probably many of you already know, from 2024. Very interesting case, which was sort of reviewed both by the Commission and by some national competition authorities. So just to give you some background on the facts, in March 2024, Microsoft announced a plan to hire almost all the personnel of Inflection AI, which was a US leading generative AI firm developing a chatbot, AI chatbot. Not just the personnel, but also the two co-founders. And this was also coupled with a number of other agreements, for example, non-exclusive licenses of the IP rights. The deal was not notified, but the Commission asked a number of questions and concluded that this constituted a transaction under the EU merger regulation, which, however, did not meet the relevant turnover thresholds. Following this, 7 national competition authorities requested a referral under Article 22 of the merger regulation, but withdrew the referral after the Illumina Grail judgment, and the Commission itself decided not to take action. However, the deal was in the end reviewed by both Germany and in the UK by the CMA. Germany applied its size of transaction test, but then concluded that the transaction lacked a local nexus. And the CMA assumed jurisdiction, but then decided to close the investigation because it did not raise specific concerns. So I think in terms of lessons that we can learn from this case, first one concerns the test. So when are acqui-hires likely to be considered concentrations? Based on the Commission's analysis, there are 2 criteria. First one is whether the target is the whole or part of an undertaking, which means that the acquisition should concern core elements that will allow the buyer to start generating turnover reasonably soon. So not just the key personnel, but likely some other tangible or intangible important assets, such as know-how or IP rights. Second criterion is the change of control on a lasting basis, or actually, referring to paragraph 31 of the jurisdictional notice, would be that the change of control should not be limited to a sufficiently short period of time. So it's actually the reverse. Even beyond the test, I think there are some enforcement challenges. First one is clearly that this kind of transaction will usually not meet the turnover thresholds at EU level. So, well, leaving aside, for example, Article 14 of the DMA, which, if the acquirer is a gatekeeper, will still require it to inform the Commission about the deal, but just inform. I think that the focus will shift on NCAs, which will be better positioned to review the deal, not just based on the basis of the merger control rules, but also on the rules on mergers below thresholds, or FSR, FDI, insofar these are not based on turnover thresholds, and also following the Towercast judgment based on Article 102 TFEU. And I think it will be interesting to see, and this is an open question still, how the EC and the NCAs will decide to review and with what outcome this kind of deals. So moving to the second issue, which is how should competition authorities calculate fines for antitrust infringements in the labor markets. So the general principle is set in the EC fining guidelines, paragraph 13, and it is that you look at the value of sales of goods or services which are directly or indirectly related to the infringement. That's the turnover you take into account to determine the basic amount of the fine. However, what I think is interesting, and it goes back to what Cesare was saying in the labor markets, is that it's not necessary that the companies compete in the downstream markets, so in the output markets. For example, in a no-poach agreement, companies might not overlap at all in the downstream market, but they may still be competing for the same talent, for example, an IT engineer. And I think it's interesting that, as Cesare was mentioning, the competition policy brief, first of all, seems to treats these kind of infringements as something akin to buyer's cartels, where the companies compete for a production input, which is labor. Second point, which I think is also interesting, is that the protection here, the goal of the protection, seems to be the dynamics of the labor market, as we were saying already. So the protection of workers. And I think if we apply all this to the calculation of the fine, it seems quite reasonable to expect that the fine should be set on the basis of the turnover of the upstream market, the labor market. However, this may pose some practical issues. First of all, how do you even allocate a turnover to this market? This is what happened in two recent cases. In Portugal in 2025, well, both 2025, the Inetum case. Here, the competition authority reasoning was that the wages paid, the compensation paid by the parties to IT consultants would not constitute a turnover because it was a cost for companies. So it looked at the downstream markets, finding that the downstream consultancy services, well, a key input for these services was the work of the IT consultants. So it found that this was a reasonable benchmark to measure the harm and the impact on competition. Another interesting take is the one of the CMA, which is more aligned with what I was saying. The CMA in this production and broadcasting of sport content case looked at the relevant expenditure, not the relevant turnover. So the wages, the compensation paid by the parties to freelance worker, because this is what the infringement concerned. The alternative to this would be, as I was mentioning, looking at the downstream product market. This, however, could be problematic because the link to the competitive dynamics affected by infringement is not necessarily there. This is what we were saying. So I think this may have an impact on the fairness of the fine. Third and final point is benchmarking, which is, of course, a very common practice across all industries, both at more institutional level, such as trade associations, and in more informal networks. There are different types of benchmarking, and except for the purely internal one, which looks at different functions and departments within a company, all the other types of benchmarking could clearly fall within the scope of Article 101 TFEU. So even beyond competitive benchmarking, which looks at competitors in the downstream markets again. So benchmarking in the HR sector may cover a wide range of information, not just monetary aspects of working conditions, such as wages and bonuses and increases, but also beyond that, working hours, recruitment strategies, pension plans. So it's really a wide variety. And in certain markets, there is an involvement of third parties, such as consulting firms, which may increase even more the transparency of the working conditions. I think a good example is the legal sector with headhunters, which have a very granular knowledge of the working conditions offered by firms. The issue, as I was saying, is not always easy for companies, I think, to protect themselves, because usually you look at your business downstream to check what the competitors are and to implement compliance strategies. But here, it may not be so clear. So what is the impact on compliance? I think an impression is that while companies are generally sensitive to the risks of antitrust infringements, there is probably still some work to do in terms of even culture, compliance culture, to start looking beyond the traditional notions of actual or potential competitors. And so I think how to do that, first of all, with a risk assessment that should go beyond these notions, go beyond the trade associations and really look at what are the day-to-day risks for HR employees and departments. Coming up with tailored compliance materials, of course, which should take into account this reality. And if needed, be ready to interact with competition authorities if companies detect some past misconduct, even dating back to some years, because I think it's quite clear based on precedent that there is no safe harbor for labor markets. I will.
Thank you. First of all, thank you to Matteo, Cesare, and Natalia for inviting me and to join this panel. And thank you to Lear for organizing also this year this great event. So today, to analyze the question of competition law applied to the labor markets, I've decided to focus on my home. As also Matteo said in the introduction, I work for a law firm, PwC Società Avvocati, which is part of the PwC network. So indeed, it's one of the so-called before. I work for a law firm. We are a law firm, so we compete on the market with all the law firms. But the general perception, let's say, is that the topic of talent mobility is indeed felt in particular in the relationship you have with the other so-called Big Four. This in relation to the legal services and all the other services which we provide, so consultancy, auditing, and advisory services. So this is why we decided to pick up this and create this brief case study. And we did this, and to illustrate this case study, I made a jump in another continent just to be on the safe side. I bumped in this article of Economics Time of India, where the focus, which focuses on the right to this point, so the talent mobility across the Big Four industries in the India market. And here the claim is that Big Four. The article is is dated back to April 24, but I saw that there is like an updated version of September, that was September 12. So the claim is that Big Four are indeed currently experiencing a very intense and sometimes ruthless form of competition in the labor market for talent. So what emerges from this trend is this kind of bidirectional flows. So you poach from us, we poach from you, and the movements which are generated from this dynamic are movement of not just individual partners or individual professional, but of entire teams, so up to in some cases tens of people. So this suggests clearly a context in which talent has become a very sensitive topic for the Big Four. And as sensitive, the article reads, to trigger a talent war as Big Four as they are now, according to the research, are aggressively investing in professional with state intention to provide full support for career advancement. And this is actually the reality which I see every day. This is something, so this is a trend which clearly applies in the European territory as well and in Italy. And for sure, so when in Italy, when it comes to competition law and competition law challenges, so the guard must be kept very high if you work in a Big Four, and if possible, even higher if it happens that your work is your job in the Big Four is like leading the antitrust department. So the ICA back in 2017 demonstrated its attention and I would say affection toward this world because open case I-796 and in the context of which all the Big Four, Italian Big Four, were fined for anti-competitive behavior in the public procurement services. So this is a point of attention, and it really draws for attention in the application of the competition law also in the labor issues. So having said this, and getting right to the point of today's discussion, back to the article, we see the article describes waves of partner poachings across the Big Four. And to this end, some very interesting data are shared. So in the last 12 months, Deloitte hired around 50 partners for competitors, while KPMG lost over 50 partners in the previous 3 years. Meanwhile, PwC employed more than 25 partners from competing firms. Similar patterns of like talent moving, I said, are reality in Italy. and you can see this more and more. And the talent mobility, by the way, is not just confined in the sense of the big four, like the four organization, because it's more and more frequent, for instance, spin-offs from big fours to similar low-end tax organization, which are established thanks to the movement of group of partners from the big four to these other independent organizations, let's say. And so this raises a question, clearly, what makes the labor market so peculiar for the big four and, let's say, big four alike, that could create specific competition law challenges. So several factors emerge. First, we compete essentially for the same talent because we serve similar clients with comparable services. So the connubium tax legal combined with the articulated basket of consultancy, advisory, and auditing services is a clear and straightforward example. So, in this sense, Big Four and Big Four alike may struggle in a certain way to differentiate between them. Second, compensation structure and career path of a professional may appear to some extent similar across such organizations. Third, the business model within the Big Four dimension appear to be more relationship driven than elsewhere, so that clients tend to follow more the individual professional than the firm. And fourth, Big Four operate in a particularly high growth environment where the average age of the professional is very low, sensibly lower than in other consultancy firm. And so this create a constant recruiting pressure. So I think that everybody sitting in this room know very well where such, let's say, common feature or homogeneity of competitive condition, let's say, can lead. So the risk is having coordination, the issue that Natalia raised about the unlawful benchmarking in the sharing of certain information, so on and so forth. And so, what's the response? What I see today happening, I see a response which is based on unilateral decision by the individual organization, which, in order to completely avoid from the onset any risk of coordination, take decisions which are based on their own strategy related to the HR field, and how this is happening. So this is happening in two ways, in my view. So the more obvious is the fierce competition on, first of all, compensation and benefits. So we do offer very competitive salary and very concrete investment in career growth. Then the other trend, the other tendency that I see is that Big Four and Big Four alike organization tend to focus much more than other firms on strong retention packages with bonuses, with the benefit packages like car, health insurance, things like this. Career advancement opportunities starting from the from early stages of the career, international mobility programs, and serious investment in skill development, so training and formation, also for starting from also a very young professional. So second way, maybe less little bit less obvious. With the provision of contractual clauses, which are aimed at governing the relationship between the organization and the professional, which are aimed, of course, at protecting the employer investment. So we are talking about client non-solicitation, that limit the ability of lawyers, of a professional to solicit, to pursue first clients, confidentiality agreement protecting client information and methodologies, and notice period allowing transition discussion at the end of the collaboration period. And last but not least, non-compete clauses. So non-compete, I think, is a topic which deserves a little bit more attention in this context. So what we know from the EU Commission soft law, so we know that the Commission brief on antitrust labor in labor markets expressly stated that under EU competition law, non-compete clauses are general outside Article 101 scope, as they are not agreements between undertakings, and thus, from an antitrust perspective, when compliant with national labor laws, non-compete clauses are considered less restrictive ways of protecting employers' investments. The question which then arises is how and to what extent non-compete clauses apply to lawyers, accountants, consultants, which have clear, straightforward professional autonomy rights. And incidentally, we can note that such clauses are not so widely used in traditional firms, law firms, first of all. This is a fact. We see very rarely this kind of clauses in the law firm dimension. By contrast, in corporate contests like the Big Four contest, there may be tendency to see this kind of provision more embedded in the structure of the relationship between the firm and the professional. So how do we look at these clauses to assess their validity and their enforceability also? So first of all, we have the civil law perspective, of course, the most straightforward, the easiest one. And we have issues like related to of course, to the assessment of the duration of such clauses, to their territorial reach. And also we look at the genesis of such clauses in relation to the professional relation between the firm and the individual professional. So are these clauses freely negotiated by both parties, or there was some compelling circumstances that vitiated in some way their inclusion in the contract? And very important, how are established the client relationship to which such obligation refer? So do these obligation refer to relationship with firm's client or with the professional clients, which makes a huge difference. So this is the civil law dimension, let's say. But then we have the strict antitrust angle of analysis. And first of all, Article 101. And here the analysis may be a little bit more tricky, a bit more complex, because the issue, first of all, and this is one of the issue that the issue that we mentioned in the beginning. So the distinction between the genuine self-employed professional and the so-called false self-employed. In other words, may there be actual ground to question the genuine independence in terms of factors such as the assumption of real commercial risk by the professional who works inside the firm, and the other main factor, the organizational autonomy. So it's clear that the analysis, the legal assessment radically changes depending on the qualification, which will be the outcome of such an analysis. Because if the professional is indeed considered an employee, the relationship will fall automatically out of scope of Article 101. A very interesting point, more specifically related to the Italian market, would be to see how we fit this kind of analysis, this kind of antitrust analysis with the Supreme Court judgments. There was also one very recent in November 2024, with number 28724, which excludes in a very straightforward way the subordination relationship between the lawyer who works in a big associated law firm. So this is for sure an interesting topic to be kept under attention. So to conclude, sorry if I was too long, what all these brief presentation suggests. So it's clear that even though the rule is well defined, the application of such rule is not so well defined. So we need for sure a case by case assessment to balance in the right way, to strike the right balance between the legitimate business protection and competition law principles. But for sure, my experience, based on my experience, I can tell that when it comes to the Big Four dimension, our path going forward clearly focus on the concept of positive retention of the talents. So in this context, I can see really the effort that every firm is striving to become like, let's say, the natural choice of the candidate, if not the only choice. And in this context, so the milestone, the three key pillars are for sure, first, again, fostering very healthy competition. Second, compliance training dedicated to the HR department. And on this, I just mentioned very, very briefly this brilliant idea I think Actecon already had in like putting together these vademecum on do's and don'ts for HR personnel. So I found it very, very, very interesting. And third, clear policies. Again, what can be done, what cannot be done, must be clearly stated in the company organization. So the message is clear. Strive to create an environment in which compliance is not perceived as a constraint, but as a competitive advantage. And at the same time, get prepared on how competition law enforcement will evolve professional services. And so maybe let's get ready for some good discussion next year on abuse of dominance in the labor market. Thank you.
Eroded our tight time slot, but if there are questions, we are more than happy to answer to those.
Hi. Hello. I'm Linus from the European Commission. I'm wondering, on coming back to the consumer welfare standard, in your legal opinion, do you think would it be possible for the Commission to intervene in cases on the basis of harm on labor markets alone? And I mean, not from a policy perspective, but from a kind of legal perspective, and then also just noting that, for example, in the court case that you referred to, I think it was said that one of the main objectives is consumer welfare, but it didn't say that it's the sole perspective. So I'm just wondering, is there something in the treaties and the regulations that would restrict, in your legal opinion, the Commission to focus only on consumer welfare?
Thank you very much. It's a $1 million question. I think it's now before the Court of Justice because it really revolves around the issue of what is the purpose of competition law and whether workers can be included in the scope of protection, as I mentioned before. I think in the end, Advocate General Emilio is a bit skeptical in his opinion. He understands that, of course, there are issues, but then he says normally in the member states, these things are regulated at national level. There are also, of course, collective agreements. Maybe EU competition law should take a step back. He noticed that the National Competition Authority, when at the hearing before the Court of Justice, was asked, okay, but what is the harm for consumers here? He said, I did not receive a very clear answer, but they were pointing to issues of fairness for workers. So clearly, there is an issue. Should it be protected by antitrust law? This would be a step ahead, obviously, in enforcement of European Union law in the European Union. I mean, normally for these kind of things, you need the court to give you support. So we are very curious to see what's going to happen in Pondela. Thank you.
Thank you. My name is Balin Basola. I'm from Budapest, Hungary. My question would be, in Italy, would you approach the attraction of, let's say, a group of employees by a certain firm from another firm as some kind of unfair competition?
It is certainly a possible theory of harm. I think the agreement to which Cesare was referring before, of like a collective agreement to take away from a competitor a group, consistent group, I would say, of professional would also qualify under Italian civil law as a boycott under Article 2598. So it's I think an alternative point of attack of such a conduct, which is a completely different body of rules, in some way easier to demonstrate because it just relates to the conduct in itself. So if you have if you are able to prove that there are high numbers of employees which are taken away their key role within the organization, I think that you have made the large part of the job in demonstrating the conditions of application of the unfair competition rule under Italian civil law.